And so we look forward to hearing your testimony, but first let me turn to the acting ranking member, Mr. Bishop.
Thank you very much, Mr. Chairman. Ranking Member Serrano would very much have liked to have been here today, but he could not, and he sends his sincere apologies. I'm here in his place, and I'd also like to warmly welcome you both, Justices Kennedy and Breyer, to our subcommittee. As has been said in the past years, this is one of the rare opportunities for our two branches of government to interact. Because of this, our questions sometimes range beyond strict appropriations issues, and as our nation's highest court, many of us look to you for important insights into issues affecting the federal judiciary as a whole, which can be especially critical in such difficult and challenging budget times as we are experiencing. We have to be careful not to allow anything to affect the ability of our federal judiciary to hear cases and to dispense justice in a fair and a timely manner. We have to be sure also to provide the Supreme Court as both the final authority on our Constitution and the most visible symbol of our system of justice with sufficient resources to undertake not just your judicial functions, but your public information functions as well. So we look forward to your testimony, welcome, and whatever we can do to make sure that we have a strong, independent, well-funded judiciary. We want to do that. I yield back, Mr. Chairman.
Thank you, Mr. Bishop. Now let me recognize first Justice Kennedy for any remarks you might like to make. We'll put your written statement in the record, and if you could keep your remarks in the neighborhood of 5 minutes, that'll give us some time to ask questions. But again, the floor is yours.
Thank you very much, Mr. Chairman. Congressman Bishop, Congressman Womack, thank you for your welcome and your greeting to Justice Breyer and to me, and we bring our messages of greeting from our colleagues. With us today, I'll just go in the order of where they're seated, are Jeff Manier, who's counselor to the President, and our counselor to the Chief Justice, and Kevin Klein, who's our Budget and Personnel Director, and Pam Talkin, who's the Marshal of the Court, Scott Harris, who's the Clerk of the Court, and is Patricia here with you as well? We have Kathy Arberg and Patricia Estrada from our Public Information Office. As you indicated, Mr. Chairman, we're always very, very careful, very cautious about budgetary expenditures, and as you well know, and as the committee well knows, the budget of the Supreme Court is just a small part of the budget for the courts as a whole, and the budget for the courts as a whole is a very small part of the United States budget. In I think a day, you will hear presentation from Judge Julia Gibbons of the Sixth Circuit on the budget for the judiciary as a whole. And this is of immense importance. She does a marvelous job for the judiciary, spends many days and weeks on this subject. And the budget for the federal judiciary as a whole, it's important, I think, for the Congress to realize it isn't just judges. I mean, there are 7,900 probation and pre-sentencing officers. And this is cost effective because this keeps people on supervised release so that they're not in custody. And this is a huge cost saving, quite without reference to the human factor. And over the years, in the federal system, we have a very low recidivism rate for those who are on release. It's high if you look at it as 1/3, but it's quite low compared to the state. So this is cost effective, and the federal courts as a whole, Mr. Chairman, are a tangible, palpable, visible, clear manifestation of our commitment to the rule of law when people from foreign countries come, as judges often come, and they see the federal judicial system and they admire it. They are inspired by it, and they go back to their countries and say that this is a nation that's committed to the rule of law, and law is part of the capital infrastructure. You can't have a free economic system without a functioning legal system. And so what you do is of immense importance, and we appreciate it. As to our own budget, as you indicated, Mr. Chairman, Overall, we have a decrease in our own court operations and expenditures. We have almost exactly a 1%, a little over a 1% increase, and that is for mandated increases for inflation and salary increases that are mandated. And over half of that we have absorbed by cost cutting in the court. So we've absorbed over half of the mandated increases within the existing framework that we have. The court is planning to have, in the year 2016, an electronic filing system so that all of the papers that are filed with the court will be on electronic filing. We waited in part till the district courts and the circuit courts could get on that system so that we could then take it from then. But of course, this also includes filings from state courts and from prisoners. We think this may require an increase in personnel by 1 or 2 people. We're not sure. The pro se petitions, of which there are, I don't know, it's in your chart, probably in the area of 6,000 a year, are usually handwritten, prisoner handwritten. When this is put on electronic retrieval commission system, you will have a database from which scholars and analysts can look at the whole criminal system, both state and federal, and make comparisons. How many, what are the percentage of cases where there's a complaint on inadequate assistance of counsel or search and seizure or a Batson violation. And so this will be a database that will give us considerable data for scholars so that we can study our system. We are, of course, prepared to answer questions about the specifics. But once again, let me thank you for the honor of being here. And my colleague, Justice Breyer, and I are pleased to answer your questions.
Justice Breyer, you're recognized.
I would simply reinforce what my colleague Justice Kennedy said and what you said, Mr. Chairman. You're here, and I think that's a very good thing. So are we, because I think our biggest problem is not necessarily the budget, but it's right similar to yours, which is how do you get the American people to understand what their institutions are about? In our case, that we're not up in some heaven somewhere where we decree things from on high, communicating directly with some mysterious source, that we're part of the government of the United States. And you're actually interested in the mechanics of how we bring this about. Good. It means we're not totally off on our own. And try to explain to people what we do, as you and try to explain what you do, and you say we're part of you, and you know, you're part of us. And that's talking to people of the United States. So I'm glad to have even a little opportunity to talk about our institution and how it works, and I'm glad you're interested. Thank you.
Well, thank you very much.
Mr. Chairman, I just might mention the Inns of Court, which you alluded to, was the idea of Chief Justice, the former Chief Justice Warren Burger. He loved all things English, and he wanted to replicate this structure in which judges and attorneys and law professors and law students have dinner twice a month and talk about substance. And he did it with Judge Sherman Christensen, the late Judge Christensen of Utah, and Cliff Wallace also assisted him. And it's been a remarkable success. It cost the government no money. And in Jacksonville, Florida, in Sacramento, California, in Boston, they have Inns of Court. And it has made a tremendous difference. People thought, oh, this is kind of an interesting idea. It's made a real, palpable, tangible, visible difference in the civility that we have within our profession. It's been a remarkable, remarkable achievement. It was Warren Burger's idea.
That's great, because that really is there to promote civility, to boost professionalism, and they're doing certainly a great job. As we begin the questions, I can't help but recall the last time you all were here, I asked you how the court decides who they're going to send over to testify before us, and I think, Justice Kennedy, you replied it's based on merit. And so you're back again. Good job. Let me ask you, one of the things that I know there have been a lot of work being done, the building and grounds. And over the last 10 years, I think this committee has spent or appropriated about $120 million to really the first time since 1935, a lot of things were upgraded. And so I wanted to ask for a kind of update on how all that work's done. The facade was redone, I guess, north and south. Is that all complete? At one time, there was a big hole in the ground next door, but since I've been by of late, everything looks really nice. Can you just give us an update on all of the work that's been done? And is that completed and finished?
$120 million appropriation and project for refurbishing of the building is completed. We came in under budget, and the project has been closed, and it's been very, very, very successful. Incidentally, the original cost for that the original estimate was $170 million. And I talked with your predecessor when I got the message, and he said, I think we've got a problem. I said, I think this sounds too high to me. We hired our own architect and worked with him. And in fact, my recollection is he did most of his work pro bono. And from the architect that we hired, he was from the University of Virginia, taught architecture there, we got it down to 120. And the building came in under that. There were some contract claims. One of the problems was the windows. If you look at our windows on the court, there are these lovely windows. So to replace the windows, which we had to do, they measured the bottom for the width of the window and then the height. But they didn't know that it's not a rectangle, it's a trapezoid. And so the window at the top is slightly smaller, and that's to give it perspective. There's a brilliant architecture. And so that was about a $15 million mistake, which we weren't going to pay for. But that's the kind of thing that comes up in the building. And it is finished. We had to replace all the wires, all the air conditioning. We had the air conditioning system from 1938, and when it broke, there was a fellow that was retired in West Virginia. We'd send a police car to get him. You know, we said we'd better fix this, and so that's been done. The facade is a different project. Some of the marble was actually falling off. The time has not been kind to the marble on the building, and so we're still in progress. The entrance, the west side of the building is finished, but the north and south and the east have yet to be done.
Gotcha. Let me ask you, and we'll have time, I think, for a round of questions or two. The whole security issue. You know, the world seems to be getting more dangerous, whether it's internationally or whether it's domestically. And I know from time to time the Supreme Court hears controversial cases. And I know that you spend about $18 million a year on security, I guess primarily with the Supreme Court police. And I just wanted you to tell us, is that adequate? And for instance, if you going to hear maybe a highly charged case, do you have to increase security during the time those hearings takes place? But just give us an overall view of how you see, because I was just in Jacksonville this morning with the folks in the federal courthouse, and that's a concern to them in these difficult economic times, to make sure we have adequate security for a lot of people that are in public service. But give us a little update on how, is that all being funded? Is that all being taken care of in terms of security?
It has been. A few years ago, we projected that we needed more than we ultimately asked for, but we're now satisfied that we have the right number. Yes, of course, in high-profile cases or when threat assessments are going up, we have increased security, but we can do it all within our existing staff.
Thank you very much. When you were last here, we discussed the very real impact of sequestration. Unfortunately, we still need to discuss that. I think most people think of federal grants and programs where you're able to dial back operations, but it's not the case with the federal judiciary. The courts have a constitutional responsibility, and you cannot control the scope of your jurisdiction. And you've already undertaken strict cost-cutting measures prior to sequestration. I know you can't answer for the entire judiciary, but what do you see as the continued effects of sequestration, and what concerns do you have if sequestration is continued?
I haven't heard the testimony for the other agencies that come before you, and maybe they'll all say that we're all unique, you can't have any sequester for us. So I don't want to just repeat the argument that you hear all the time. But a few things. Number one, we can't control our workload. It's controlled by forces and factors that are beyond our direction. Number two, we have a tradition, as the chairman indicated, of being very prudent and very cautious. With us, if there were cutbacks, it would mean delayed processing time of cases, and it could mean compromises in security. With the courts in general, it's much more significant. As I indicated, we have 7,900 probation officers, and if they're laid off, that means more people are in prison at a greater cost. So sequestration actually works backwards.
Yeah, I agree. At some point, you've cut back enough and keep going, you will discover that unfortunately in the United States, there are crimes and people are arrested and they are supposed to be tried. And you need a judge and you need a jury and you need a courtroom. And the alternative is not to have the trial. If you don't have the trial, the person has to be released. And there we are. And so there is a minimum, and if you go towards that minimum and beyond it, you will deprive the country of the services that basically are needed to run the government of the United States in this area.
Thank you. I applaud the court's ability to find savings in its budget. Your total FY16 request for salaries and expenses and buildings and grounds does represent a discretionary decrease of 1.1% from FY15. It looks like this is a combination of the construction work being completed and savings from non-recurring costs that are associated with the implementation of your new financial system. Are there program increases that you are delaying but you still feel would be beneficial at some point? And with regard to implementation of your new financial system, which I understand you're leveraging resources from the executive branch, the Department of Interior, specifically in the area of payroll and financial tracking. And I understand that this move has reduced your reliance on contract employees, and it seems to be a great step toward efficiency. Do you find that you're getting the same level or an improved level of service, and would you recommend this to other agencies that are looking to reduce their costs?
Well, I'm not enough of an expert to recommend it to other agencies, but our staff tells us it's working very, very well. They like it. They like it better than the outside contractors, and it's much cheaper. We are in partnership with an agency in the Department of Interior, and which has some similarities to us, and it's been the source of, it's generated most of the savings that we've had over the last few years.
Thank you, Mr. Chairman.
Thank you.
Well, and
It's
part of the
interesting that
question,
we could have
Congressman Bishop, we're not holding back on anything, other than we do have this projection that we may need two more people because of the electronic filings that we're going to put in place in 2016.
I must remark, thank you very much, Mr. Chairman, that the answers from our witnesses are so succinct and to the point, concise.
Yeah, we don't, not only do we not get people requesting less money, we don't get people that speak clearly and concisely. So congratulations on both.
As in past years, our ranking member, Mr. Serrano, and I continue to be interested in the increase in the number of minorities that's elected for Supreme Court clerkships. Those are prize plum positions for youngsters coming out of law school. I know that there's been an initiative in place at the federal judiciary to help recruit minorities into clerkship positions. Do you think that those efforts are beginning to bear fruit at the district and the appellate levels, and are there similar efforts underway at the Supreme Court?
I think they're beginning to bear fruit, and we're conscious of it. The district courts and the courts of appeals are a little bit more open, in part because they're around the country and they take from local schools. Some of us tend to take from the Ivy League schools. And not that they're without their pool of
Minorities.
of minority applicants, but we are conscious of it, and it's important, and it's a valid question.
When I started on the court, I don't know the figures in lower courts, but I mean, in my own case, it might have started out that I had to look, especially hard. I don't know. I mean, it's not a problem. I don't think I mean, at least in my case, maybe that's been locked, I don't know. But it seems to me, if it's at all, if I'm at all typical, the problem is diminished significantly, really significantly. I could try to do some counting, but I can't in my head. I think of the individual people. And I don't think, but they're
In 2014, we had 15% minority clerks on the Supreme Court.
Thank you. Let me move to another subject area. I know that at previous hearings, we've discussed the possibility of applying the Judicial Conference's Code of Judicial Conduct to the Supreme Court justices and to make recusal decisions by the justices more transparent for the public. Currently, the Code of Judicial Conduct applies to all of the federal judges, but is only advisory for Supreme Court justices. Do you have any thoughts on the proposals for changes to that since we last discussed the issue, I think last year? Do you believe that the Code of Judicial Conduct should apply to Supreme Court justices and that recusals should be more transparent?
You prompt me to go back and do some research, but my first response to your question is that recusals are largely governed by statute and by principles that are not necessarily part of the Code of Conduct. Now, there's an argument that the reason for recusals should be more apparent. I'm not sure about that. In the rare cases when I recuse, I never tell my colleagues, oh, I'm recusing because my son works for this company and it's a very important case for my son. Why should I say that? That's almost like lobbying. So in my view, the reason for recusal should never be discussed. It's obvious sometimes when Company A is before the court and our public disclosure statement indicates that a judge owns stock in Company A, and so that's fairly obvious.
I had one thing, two things. One is we all have or access to the volumes of the Judicial Code of Ethics, and having been there for some time now, 20 years, I'd say I have not seen an instance of recusal by me or anybody else where the judge doesn't make sure it's consistent with the problem is consistent with the Judicial Code of Ethics. So it to say, well, it's advisory as opposed to compulsory. Compulsory is words. It doesn't really make a difference in practice. Now, well, why not? What is it I'm nervous about? Why not just say, well, it should become, I'm nervous about this. The Supreme Court is different from a court of appeals and a district court. And that's true, by the way, with television too, interestingly enough. Why is it different here? Because in the Court of Appeals, if I recuse myself, or in the district court, they can get another judge. Judges are fungible. They're not in the Supreme Court. You can't get a substitute. And I wouldn't say there's any lawyer in the country who would do this, but it is logically conceivable that a lawyer might sometime think of the idea of bringing up an issue in order to have a panel that is more favorable. I know no such lawyer. But it is conceivable. And therefore, I think we have to be careful. Because unlike those in the lower courts, I can't think, well, in case of doubt, just recuse yourself if it's a close case. No, I have a duty to sit
as well as a duty not to sit. And moreover, I have a lot on my schedule. I have a lot to do, as do you, as do others. And trying to make this into some kind of big issue, I would prefer not, because I mean, I would think no is the answer. I have to make those decisions. I will make them as best I can. I will do it according to the Code of Ethics, and so far I've been able to do that, and I don't want it to become an issue. And all that leads me to say, no, I don't want to have to give my answers if I don't want to. And I have to, it's a personal decision. I will follow the code, and that, I think, is the best way to run this institution.
Thank you very much, Mr. Chairman, and I will hopefully be brief. I noticed that the court's caseload is much lower compared to previous years. The current range of cases is literally half of what it was 10 years ago. Does the court have a target number of cases that you target each year? And let me just go back to another subject. You talked about the new crop of young lawyers coming out of law school. When I went to law school because I saw the law as an effective way of promoting social change. I came out of law school in 1971, and I was a part of the civil rights movement and interpreting the Civil Rights Acts of 1964. And so I'm very, very sensitive to the way that the law can be used to perfect social change, and has been, and the way the Constitution has evolved. But there are reports from judges all across the country that the recession has not only caused a spike in the number of pro se litigants in civil cases, but has negatively affected the parties themselves and the courts. Do you believe that our justice system loses its effectiveness when citizens are unable to afford legal counsel in cases with stakes involving family, shelter, and livelihood? And if so, can you perhaps give us some thoughts of how the problem can be remedied with more resources being allocated to pro bono or to legal aid services? My major piece of litigation, civil rights, was in behalf of 6,000 African-American inmates in the Georgia State Prison who were in a desegregated system, occupying the same space as 4,000 white inmates. And it was certified as a Rule 23 class action case. Judge Alamo decided it down in the Southern District of Georgia back in the 70s, which resulted in a total change of the criminal justice housing system and the system as a whole, relieving overcrowding. So it was brought pro se, and I happened to be a cooperating attorney associated with the NAACP Legal Defense Fund, and I handled that case, and they, as a pro bono firm, backed it up. So it was at no charge to the litigants. But there are not that many of those kinds of opportunities, and there are, with the economic recession and with pro se litigants, particularly in civil cases, how do we deal with that in terms of making sure that our justice system really is not turning on the capacity and the financial resources of the litigants?
As to just number of cases, the first part of your question, is there an optimal amount that we strive for? We take the cases where we think our guidance is needed. As you know, we wait for courts of appeals or state Supreme Courts to be in conflict. And optimally, we probably should have about 100 cases a year. When I first came, we had something in the 160s, 180. It was just far too many. The cases we do get now, I think anecdotally, I haven't seen studies on it, are somewhat more difficult. Patent cases, we had a case, I think it was 2 terms ago, on the patentability of DNA. I read all summer long about it to try to understand it. I ended up, Justice Thomas wrote the opinion, a very good opinion. So I think our cases are more technical. And the 78 cases that we had last year exhausted us. But optimally, we could handle, I think, about 100. But we wait, because we wait until our guidance is needed. On the broader question of representation in civil cases, I saw some numbers in which the number of unrepresented parties in civil litigation is actually increasing because of some of the factors you mentioned. Now, the Congress has enacted bankruptcy laws which are, I think, well suited to a modern society. The bankruptcy reform statutes are good. And so I don't think there's any real problem in the bankruptcy area. And our bankruptcy judges are just very, very good. So that system, I think, is working. But in the area of standard civil litigation, I think there is a problem with unrepresented parties. And law schools can and probably should do more. And they should focus again on the small cases, not big firm stuff.
No, I had a couple of things. On the number of cases, there's a big decline beginning really in the late 80s. Now, the way we select cases almost entirely, not completely, but almost entirely, is you look to see if the lower courts have come to different conclusions on the same question of federal law. Now, they do or they don't. And if they do, we'll probably hear it. And if they're not, we probably won't. Now, there are other things, holding a law unconstitutional, et cetera, but that's the main thing. So I have not noticed any tendency whatsoever to try not to take cases. Rather, Sanford used to sit there, O'Connor, and say, "We've got to take cases." Now he does this. He says, "Well, can't we take some more cases?" So they're not. The conflicts are less. Now, why? That is, in my own explanation, which has no particular validity, is that you have seen in the 70s and 80s what you saw from 1960s, when I was a law clerk, 60s, 70s, 80s on, tremendous civil rights laws, statutes of all kinds, Title VII, a civil rights revolution, a revolution beyond that in the way that the first 10 amendments applied to the states. Well, for a lawyer, every word in a statute and every new major case is a subject of new argument. So you pass statutes with 50,000 words, you'll get 50,000 cases. Now, suddenly there has been in Congress a kind of increased legislation and major statutes. And those statutes are long. And they have many words. So we can predict whether I'm right or not. Because if I am right, then there's a lag. You see, there's a lag because they all have to. 5 years, 7 years from now, we will see the number of cases in the Supreme Court growing because those words will be capable of different definitions and judges will have reached different conclusions. Now, I don't know if that's right. It's a theory. Okay. On the representation, when I did look at some numbers a few years ago, we're way behind. Compared, say, to England or to France. And part of it is in England, there is an appropriation. And I don't know where it is on your list. And that's a problem. And in England, by the way, where they had a very good legal representation system in civil matters, they're running under budget pressure. And the lawyers who are in this field are all worried that there are cuts, and there are. In France, they have a different idea, which is sort of interesting. The bar itself provides a lot more free representation than here, but there's a price to be paid. The price to be paid is that the individual lawyers and the bar will be ruthless in segregating the sheep from the goats. So if you go to a lawyer, you will get your free representation if you can't afford it at the cost of having him and or her and his colleagues, you see, going through your case and making a ruthless decision about whether they think they really can win it. But the result of that is the people they think they have a good shot, they will get the free representation, much more even than in England.